What is hire purchase? Hire purchase is the hiring of goods with the option to buy the goods at the end of the hire purchasing term. If you take on HP financing, you are the hire and the financer is the owner. As a hire, you will have to repay the financer based on the agreed duration while you have possession of the vehicle. When all the installments are paid up, ownership is the transfer to you. Governing legislation, the Hire Purchase Act 1967. Hire purchase transactions are governed by the Hire Purchase Act 1967 HP Act. The HP Act set out the form and contents of HP agreement, the legal right, duty, obligation of hire and financer. The HP Act is administered by the Ministry of Domestic Trade and Consumer Affairs. Definition of hire purchase. Section 2, bracket 1 of the Hire Purchase Act 1967, hire purchase agreement include a letting of goods with an option to purchase, an agreement for the purchase of goods by installments, whether the agreement describe the installment are rent or hire or other ways, but does not include any agreement. First, whereby the property in the goods comprised therein pass at the time before delivery of the goods. Second, under which the person by whom the goods are being hired or purchased is a person who is engaged the trade or business of selling goods of the same nature or description as the goods comprised in the agreement. Parties in a hire purchase agreement. First, hire. A person who or has taken goods from an owner under a hire purchase agreement and includes a person whom the highest right or liability under the agreement have passed by assignment or by the operation of law. Second, owner. A person who let or has let goods to a hire under hire purchase agreement and include a person to whom the owner's right or liability under the agreement have passed by assignment or by the operation of law. Last is guarantor. An owner may require a hire to furnish a guarantor or such number of guarantors acceptable to the owner to guarantee the performance of the hire's obligations under the hire purchase agreement by virtue of Section 20A of the Act.
Next, I will talk about formation for a valid hire purchase agreement. There are three formations, which is before agreement, during agreement, and after agreement. First thing first, I will talk about before agreement. Under Section 4.1 of the Hire Purchase Act 1967 HPA, a potential hirer must be given notice of the second schedule by the owner. It must be a true written statement signed by him in accordance with Part 1 Second Schedule form. When a dealer conducts the negotiation that lead to the formation of a hire purchase agreement, the dealer must give a prospective hirer a complete written statement signed by him in accordance with the form set out in Part 1 Second Schedule, and after that serve Part 2 of the Second Schedule. Is the contents of the schedule. The first one is the description of the goods. The second one is statement whether the good is new or second hand. Next, address where the goods will be kept. Then cash price. For the fifth one is deposit. Under Section 31, the deposit is not less than 1/10 of the cash price of the goods. For the sixth, insurance or fees. Next, term charge. Rate per annum, total amount of the term charge. Next one is difference between cash price and total amount payable. For the last one is the installment payments. Is during agreement. Hire purchase agreement to be in writing. Under Section 4A, a hire purchase agreement for any product listed in the first schedule must be in writing. Otherwise, the agreement will be void and the owner will be committing an offence under this Act. Next one is hire purchase agreement to be signed. Under Section 4B1, all parties must be signed the hire purchase agreement. Section 4B2, no owner, dealer, agent or person operating on behalf of the owner may force the signing of a hire purchase agreement, form, or document unless it has been properly completed. Okay, under Section 4C, this is the contents of hire purchase agreement. The first one is a date on which the hiring starts. The second one, the number of installments to be paid by the hirer. The third one is the amount of each installment. The fourth one is the time for the payment. Next, a description of the goods sufficient to identify term. And the last one is the address where the goods are kept. Okay, next for during agreement. Under Section 4D, there must be a separate agreement for every items unless the goods are sold as a set or complementary of each other. Under Section 4E, the hirer can keep the motor vehicle registration certificate. Next, under Section 4F, there must be no alternation or modification of the motor vehicle. For the last one is under Section 4G, if the good is a second-hand, the owner must make a declaration of second-hand motor vehicle and compulsory inspection by Puspacom. Okay, here is the case under Section 4B, which is Ming Lian Corporation Sender Berhad versus Haji Nordin. The court gave a decision that the enforceability of a hire purchase agreement was not affected if the hirer signed an agreement with blank space which were later filled in by the owner, provided that the hirer was aware of the terms and knew what he was signing. The defendant in this case had signed an agreement with a certain portion of it were blank. The particulars were filled in after the agreement was signed. Or the last one is after agreement. Under Section 5, within 21 days after the hire purchase agreement is completed, the owner shall serve on each hirer and guarantors a copy of the agreement. And of course, there will be effect if not comply. The hire purchase agreement is void and the owner shall be guilty of an offence under this Act. The penalty under Section 46 HPA, fine maximum Rm 100,000 or imprisonment maximum 5 years or both.
Under hire purchase agreement, you have to know that you are the hirer and the owner of the financial institution that give you the loan. Once you become the hirer under the Hire Purchase Act 1967, you are entitled to the following statutory rights. First, right to copy of agreement and statement of your current position. You may request the owner to provide a copy of hire purchase agreement and a writer's statement showing the amount paid, unpaid and payable under the hire purchase agreement and the amount derived from interest or overdue installment. Second, right to appropriation of payment when you have more than one agreement with the same owner. You have the right to appropriate payment, divide the payment, where you have more than one agreement and the payment is insufficient to discharge the total amount due. For example, you have two hire purchases agreement where the total amount of monthly installment is Rm 1000. For May 2015, you have only Rm 800. You have the right to discuss with the owner to appropriate the payment. Third, right to apply for an order for goods to be removed. It is compulsory for you to keep the goods in a place stated in the agreement, but you can ask the owner for permission to move the goods to another place. If the owner refuses, you can apply to the magistrate court. Fourth, right to assign your right under the agreement. The law allows you to give your right title, and interest under the hire purchase agreement to another person with the consent of the owner. 5th, passing your right by operation of law. On the hirer's death, all his property and rights under the hire purchase agreement will be passed to his personal representative, who must comply with the provision of the agreement. 6. Right to early completion of the agreement. If you think that you want to complete the agreement earlier than the agreed period, you must give notice in writing to the owner of your intention and pay all necessary payment under the agreement. 7. Right to terminate the contract. If you cannot afford to proceed with the installment payment, you may terminate the hire purchase agreement by returning the goods to the owner. 8. Right of hirer on repossession by owner. Do you know that during repossession, where the owner takes possession of the goods because you are unable to pay the installment, you may introduce a cash buyer to the owner. You are entitled for any difference between the amount which have been paid by the cash buyer with the value of the goods. Lastly, right of hirer in respect of term charges exceeding the prescribed rate. The term charges should not be higher than the prescribed rate, 10% per annum. If the charge is higher, you have two options: either to treat the hire purchase agreement as void or to have your liability reduced accordingly.
The procedure of repossessions by the owner. At the common law, the owner has the right to recover possession of the good if the hire commit a breach of obligations under the Hire Purchase Agreement. The Hire Purchase Agreement Act 1967 lays down various restrictions on the power of the borrower when recovering possession. First, Section 16. Notice must be given to the hirer when goods are to be repossessed. Second is Section 17. After repossession, the owner must not sell or dispose of the good for 21 days. The third one is Section 18. Higher rights and immunities when goods are repossessed. The last one is Section 19. Higher can retain possession of the goods in certain circumstances. Okay, now we will talk about the Section 16. Section 16 is a notice must be given to the hirer when goods are not to be repossessed. An owner should not exercise any power of taking possession of goods comprised in the hire purchase agreement arising out of any branch of the agreement relating to the payment of installment unless the payment of installment amounts to not more than 75% of the total cash price of the goods comprised in their hire purchase agreement, and there have been two successive default of payment by the hirer and he has served on the hirer a notice in writing in the form set out in the fourth schedule, and the period fixed by the notice has expired, which shall not be less than 21 days after the service of the notice. That is the Section 16.1. Okay, now we will talk about the case under Section 16.1. 16.1. Okay, the case is Bank Brothers Motor Syndrome Berhad vs. the Lee Exchange 1978 1 MLG 179. The fact is the car was taken by the respondent on hire purchase with the appellant. The respondent failed to pay the installment due and the appellant issues a notice under Section 16.1. The issue is whether the notice under Section 16.1 was in fact served. The help in Section 16.1 clearly specifies that the period before which the seizure can take place shall be not less than 21 days after the service of the notice. However, the date specified in the notice was 2 days short of the statutory minimum and the notice was therefore bad in law even if served, and its effect was therefore null and void.
After repossession, the owner must not sell or dispose of the goods for 21 days. Section 17. By virtue of Section 17A1, no person shall undertake repossession of goods comprised in a hire purchase agreement without a written permit issued by the controller. Any person who contravenes subsection 1 shall be guilty of an offence under this Act Section 17A2. It is an offence to appoint a non-permit holder to undertake the repossession of goods comprised in a hire purchase agreement Section 17B1 and Section 17B2. Section 18 of the said Act lays down the various rights and immunities enjoyed by the hirer.
So, I will talk about hires' rights and immunities when goods are repossessed. Section 18. Operative of 5th SN. The hire may within 21 days give notice to the owner requiring the owner to redeliver the goods. The hire has to settle the installment due and others payments such as the cost of repossession and storage. 2. Sell the good to any person introduced by the hire who is prepared to buy for cash not less than the estimate values of the goods. The case that I found under Section 18 is Yusof Muhammad J in the case of Hong Leong Finance Berhad vs. Lee Cheng Heng. Facts: the net amount payable for purpose of Section 18 in the total amount payable less statutory rebates for term charges and insurance. The value of good is the best obtainable price or the cash paid by the person introduced by the hire, less reasonable cost of repossession including storage, repair and maintenance charges, and reasonable cost of selling or attempting or otherwise dispose of the goods issues. This is by virtue of Section 18 3A and B of the Hire Purchase Act 1967. Hence, under Section 18 4A, it is provided that where the owner intends to sell the goods by public auction, he must serve on the hire a copy of the notice of such public auction not less than 14 days of the date the said auction is to be held. Therefore, when the owner takes possession of goods and required to sell them by public auction, he is responsible to ensure that the goods are sold at the best market price. If the owner fails to comply with such requirement, the hire will be stopped from reducing his losses. In addition, Section 18 4B ensures the statement that if the owner intends to sell the goods or otherwise than by public auction, he must give the hire an option to purchase the goods and the price. When he intends to sell, if the price is lender the owner's estimate of the value of good repossessed. If the owner fails to comply with this requirement, he shall be guilty of an offence. Next, I will talk about hire can regain possession of the goods in certain circumstances. Section 19. Section 92 provide that where goods are returned to the hire person to subsection 1 above and any breach of the hire purchase agreement has not been remedied, the owner has no right arising out of the breach to take possession of the goods unless by notice in writing given to the hire at the time of the return of the goods he specified the breach and require it to be remedied, and the hire fails within 21 days or within the time specific in the notice, whichever is the longer, after receiving the notice to remedy the breach. In contrast, for hire purchase contract not governed by the Hire Purchase Act, the owner can proceed to recover the hire purchase facility in the usual way. This is HSBC Bank Malaysia Berhad vs. Overseas Industry Sdn Berhad 2008. Facts: the plaintiff extend to the defendant several credit facilities secured by a charge on the plaintiff's land and a hire purchase facility subsequently, under which term the defendant undertook to allow the plaintiff to create a charge over the land to secure the repayment of all monies due under the HP facility. When the defendant opposed the plaintiff application for an order for sale of the land, inter alia contending that the statutory notice from 60D was invalid and ineffectual, and that there is a cost to the contract in the plaintiff's application for an order for sale of the charged land. held release, allowing the plaintiff application that in the particular crime question of that case, the amounts claimed by the plaintiff in the Form 60D were not disputed. It was well within the knowledge of the defendant that the plaintiff was entitled to combine all monies due and owing by the defendant on any of the defendant's account with the plaintiff, merely because the plaintiff had elected as it was entitled to do so within the term of the charge and measure to combine the amount due and owing under the HP facility. It could not be said that on balance the defendant was prejudiced or misled. In the crime questions, the Form 60D stationery with notice was effectually and valid in law.